In this law module number 7, we're going to take a look at the major case that dominated American history in the second half of the 20th century. It is the famous case of Brown versus the Board of Education.
Today we reflect on the courageous moments in the lives of a handful of trailblazers. Whether through their own determination or by circumstance, one choice, one risk, one decision that they made changed our country, and in most cases, the world. First, the Honorable Thurgood Marshall. Before he became a Supreme Court justice, he was a tenacious Baltimore attorney in a well-worn wool suit.
1930. In the South, everything is separated by race. From water fountains to hotels, from restaurants to public transportation. And nothing is equal. In the North, things are a bit better for blacks. Somewhere between these two worlds is a young man from Baltimore, Maryland, whose birth name is Thurgood Marshall. When Marshall was a kid, his working-class father found an unorthodox source of entertainment for his young son. It would have a lasting impact.
His father would often take young Thurgood Marshall into the courts in Baltimore City just to watch the proceedings, much like entertainment, and point out to Thurgood Marshall what was going on.
Thurgood Marshall was born on July 2nd, 1908. Before he reaches his teens, however, he shortens his name to Thurgood. Thurgood grows up in an integrated Baltimore neighborhood, but even in that diverse city, racial tensions lie just beneath the surface. Marshall's exposure to both integrated and segregated environments shapes his philosophies about race.
Imagine in your mind something that's created in the midst of a storm, the tensions that come between North and South, and that spirit, that energy is Thurgood Marshall.
After receiving his bachelor's degree from Lincoln University in Oxford, Pennsylvania, Marshall decides to continue his education. He would prefer to attend a school that's more affordable and closer to home, but an ugly reality intrudes.
Thurgood Marshall wants to go to the University of Maryland Law School, but he can't attend that school because the school is limited to white students, so his mother has to pawn her wedding ring, her engagement ring, so that Thurgood Marshall can come to Howard University Law School in Washington, D.C.
Marshall arrives at Howard in 1930. There he meets law school dean and respected constitutional law expert, Charles Hamilton Houston. Houston takes the affable Marshall under his wing. The year Marshall graduates, Houston is troubleshooting potential cases for the National Association for the Advancement of Colored People, the nation's leading civil rights organization. Houston invites Marshall to accompany him on fact-seeking missions in the South. The target? Public schools. There they find the conditions of black Southern schools to be appalling. Both men hope that what they learn on this trip will lay the foundation for something much bigger.
You've got two black men going down south in an old jalopy, looking at the black schools and the white schools, taking notes to build a brief that one day they want to present to some court to say, separate but equal is a farce.
By December 1935, an invigorated Marshall finds a willing participant to help him sue the very law school that would not accept him because of his race. He takes the University of Maryland to court. In a dramatic end to a long-standing hurt, he wins the case. It would be the first of many precedent-setting court victories for Thurgood Marshall.
That's why he is known as a social engineer. And Thurgood Marshall was somebody who, with diligence, courage, a sense of humor, and incredible preparation, changed the American legal system.
In October 1936, Marshall moves from Baltimore to the New York headquarters of the NAACP. New York City is the place for up-and-coming blacks. While in New York, Marshall's caseload grows, as does his experience and his profile. He cuts an imposing figure in and out of court.
Outside the courtroom, he was very gregarious, good-looking guy, great dresser, chain smoker, loved good scotch, who was a colorful figure. When it came to knowing the law, he was Clarence Darrow.
Marshall spends much of his time in the South filing cases and testing racial boundaries. Working below the Mason-Dixon line, he is taking serious risks.
He had to have courage to go into that courtroom and leave there every night knowing that some people hated him simply because of the color of his skin.
But despite obstacles, the young lawyer's career is on the rise. In 1940, Marshall argues his first case in the U.S. Supreme Court, a case involving coerced confessions by several black men. Marshall wins. Over the next decade, he becomes a seasoned trial lawyer and head of the NAACP's Legal Defense Fund. By 1950, Marshall could claim 10 victories at the U.S. Supreme Court. But it is not until 1951 that Marshall and the NAACP can begin to put public school segregation to the test in earnest.
We believe that now is the time to get around to having our Constitution applied to all sections of the country equally.
In the spring of 1951, the NAACP files separate suits in federal court. These cases in Kansas and South Carolina claim segregated public schools are inherently unequal and therefore unconstitutional. Although Marshall and his team lose in the lower courts, the U.S. Supreme Court agrees to review the cases. The justices add 3 similar cases to the docket. These 5 suits will be heard together as Brown versus the Board of Education.
These extraordinary lawyers brought these 5 cases showing that the problem of segregated education had a profound impact on African American children throughout the United States.
At 44, Marshall faces what some would call the most important case of the century, certainly of his life. On December 9th, 1952, oral arguments begin before the nation's highest court.
The NAACP strategy was to go after public education for children. Why? The idea was that education was the area where there would be least resistance, most sympathy, in respect for the right that we can't punish children.
In court, Marshall and his team employ unique tactics to convince members of the highest court that Plessy versus Ferguson, the 1896 case, which legalized separate but equal education, is now outdated and untenable. They included the results of an experiment with black children.
The data showed that black children associated a white doll with positive characteristics and a black doll with the negative characteristics, indicating that the pattern of segregation had caused them to identify persons of their own skin color with many negative stereotypes.
Even as Marshall defends the rights of children to have an equal education, his own rights are being curtailed.
He would go to the Supreme Court and argue a case and win, but he would remind the other attorneys, I hope you brought the peanuts. Now, what he's talking about the peanuts is that black lawyers couldn't eat in the restaurants around the same court where they were arguing for equal justice under the law.
As the case moves forward, Marshall is exhausted. He often sleeps at his office. He seldom sees his wife. His team has been working for years on this case, but to him, the people he is representing are most important. On Monday, May 17, 1954, the Supreme Court comes to a decision. Marshall knows that only months before, the justices had been deadlocked. In the courtroom, as he awaits the verdict, he scans the bench to get a read on the outcome. As Chief Justice Earl Warren delivers the court's decision, Marshall hears these words: "We conclude that separate but equal has no place." In a unanimous decision, the justices find that the long-held separate but equal doctrine is inherently unequal and unconstitutional. Marshall and his team emerge from the highest court victorious.
The case in 1954 was the cleanest, purest victory we've ever seen in the case of race. And Brown was responsible for creating more black professionals than anything that had happened before.
Marshall isn't done making history. In 1965, he becomes the first black man to represent the government's interests as the Solicitor General. After being nominated by President Lyndon Johnson in September 1967, Marshall is appointed to the U.S. Supreme Court. He is the first African American to hold the post. He goes on to serve for almost a quarter of a century. Yet his victory in Brown versus the Board of Education is his greatest legacy.
It shifted the balance of the law from being a headwind to a tailwind, because it said that the federal law is going to support you and your right to equal opportunity and equal education.
Because of what they did more than 50 years ago, people like me from all over the world, from all over the nation, had opportunities for education.